section 3 are the personal property and the fixtures. What items are you getting as part of the purchase of the real property? This is the personal property. These items are marked and you want to make sure they're there. Also, as Jesse would tell you, he's our inspector. You might want your inspector to not only check to make sure they're operating, but also to get serial numbers or take pictures just to verify that those are the same items when you close. You also note there may be some items that are not part of this contract, that they're going to take something with them. Let's say there's a antique mirror on the wall and you like that, but that's something that's been in their family for years, and they would say, okay, that looks nice, but that mirror will not be part of this purchase. We're excluding it, and we'll put another mirror there in its place. Also on the line below that, they will have items that may be included. So there may be a hot tub in the backyard. Maybe there is a swimming pool. Maybe there is a swing set or a shed or something like that. You want to look at those extra items to make sure you want them. And if you don't, you may want the seller to remove them prior to the closing. Hot tubs are, if you want to make sure, if you're going to get a hot tub, make sure it works and that it's not just sitting out there and doesn't operate, because it can be expensive to have it removed. So think about some of those things. Continuing down that page, where you have the purchase price, you have on line 39 there a credit at closing. This is something you want to discuss with your agent, with Pedro, as to whether or not you might up your offer, but then ask for some closing assistance from the seller, getting some money back at closing to help with your closing costs. Below that is the earnest money. The earnest money is a representation of good faith that you are willing to go through with this, and you put some money down to show this. How much? I usually say 1,000 to maybe 3. I don't like to see too much earnest money down, just in case there's ever a problem that you, the buyer, don't want to go through it, and you're willing to lose the earnest money as opposed to purchasing a home you don't want to purchase. Earnest money would be returned if one of the contingencies are not met, so you would not lose it that way. One of the things I don't like about the other contract, the Chicago Board of Realtors contract, is they like 10% down for their earnest money, and I feel that's just too much money unless it's a unique deal. Next page, please. On this page, you'll note paragraph 5, which is the closing. You have to choose a closing date, and this is something you should be discussing with your agent, what your needs are. Do you have a lease that's up at a certain point and you have to be out of your apartment or out of your house? Do you have some flexibility that you can close sooner, but you want to do some decorating or take your time moving in and stuff like that? Also, this date, you're going to have to know whether or not the seller can accommodate that date. Have they put this property on the market, but they have hoping to sell it and they have not yet purchased their new home? So they might need more time for a closing date. So those are some of the things you need to think about. Do you need to be in your property on a certain date in order to qualify in a school district? If you're moving to a new area and you're concerned about the schools, you might want to check on what their residency requirements are. Some will let you register children with a signed real estate contract. Others will not without proof that you have closed. So that's something I think you should check out. Section 6 is possession. In Illinois, possession is granted and given at the closing. So you give them your money, they give you the keys. Sometimes we run into issues where the seller cannot get out of the property, or the seller has not removed all their possessions when you do your final walkthrough. If they cannot get out and they ask you, they say, you know, hey, we need some more time, I caution you about that, about being a nice person and granting them more time, because what happens is they become a tenant and you become a landlord. And if they do not get out in time, let's say they need 2 extra days, you then have to go to the formal process of evicting them, which is, if you know anything about Cook County, right now evictions are scheduled out through July 15th, I think. So any date you would get would be after that, and there's a lot of pent-up frustration coming with that. So be very cautious about agreeing to that. Typically, I would suggest that you don't grant them that, but we delay the closing, giving them more time, so you get your possession on the closing date. Possession in other states differs. If you buy in Wisconsin or you buy in Michigan, you would close on a date, but the seller would have up to 30 days additional time to get out before possession is given to the buyer. The next section is the financing. What are you looking for? What type of loan? How much time do you need to get that loan? What percentage is it going to be an FHA loan? And those are things that, again, you're going to discuss. You should have some idea and discuss with your agent and most definitely with your lender. If you would flip, please, next page. When you look at a property and you make an offer and they accept your offer, you should receive what we call certain disclosure forms. In Illinois, they have the Residential Real Estate Property Disclosure Report, which is a form similar to this. This is a title company report. If you could roll down for us, please. There are 23 points on this report, and it shows yeah, that's fine. Okay. Shows the condition of the property. Are there any defects? The first thing you got to look at, does the seller know anything about the property because they've lived there? So if they haven't, they can mark no, and then they may not know anything. If they are aware of a issue, as per the boxes, they have to let you know or mark that they do not know. The big one, the interesting one in this form is number 23, which says that this property was used as a meth house. If they have marked that, that may not be a good choice that you want to necessarily take an option on and may want to move on. So that is the Illinois Residential Disclosure Form. The next form that you're going to see, thank you, Evie's highlighted it.
I'm working, I'm playing with it.
That's great, thank you. I try not to highlight the meth house, and there you go. The next form that you're also going to get is the lead paint hazard disclosure. This is a form that you will get. I'm sorry?
Is it page 8, the next one?
Yeah, next one.
Okay.
Should be the next 9.
9?
Yes.
There we go.
There we go. Okay, thank you. Again, this is the lead disclosure. Lead paint is a hazard, as you probably well know, and it can be detrimental to not only children, but also adults. So if the house was built before 1978, odds are there is lead paint within the house. Most times it's not an issue because over the years people have encapsulated it by painting over it. You might run into a problem if you're going to replace windows or doors or something like that, where you find older paint or chips and stuff like that, in which case you then have to be very cautious and careful, and to remove any lead issues, you need certified contractors to do that, and they basically come in with hazmat suits and things like that. Lead is a problem to children because lead has a sweet taste. Through the years and history and stuff, they have included lead in liquor, in medicines, and things like that to kind of mask taste and give things a sweet taste. But it is damaging to the brains. Also, if you are remediating it, you got to be very cautious because if lead particles get into the air, they can be dangerous that way also. So they give you that. If the property is built after 1978, you don't have to worry about this because the government outlawed lead in paint, and you will not get the disclosure. Next, please.
Mold?
There should be one before the radon should be before that.
Ah, okay. Page 10.
Yes, please. The next required disclosure in Illinois is a radon disclosure. And this is a statement whether or not the seller is aware of radon on the property. Radon is a naturally occurring gas that can be found anywhere. The problem with radon is it has been linked to cancer. So if your inspector or you suspect that there might be radon on the property, you can have it tested. A home inspection does not typically include a radon testing. Usually you can do it yourself or have it done. You can go to Home Depot or one of Menards or something like that and get a testing kit. It's a can. You have to secure the area, lock, close windows and stuff like that. Open the test, let it go for about 48 hours, and then you send the results in. If you hire a radon testing company to do that, they basically do the same thing, but they get the results and all that. If the radon reading is above 4.0, then it needs to be remediated, and the seller should do that. Typically a $1,600 to $2,000 expense. And what they do is they dig a pit, kind of like a sump pump pit, and they put a pump in there, and then they, through the sides, out the sides of the building, they will run plastic tubes, usually 2 to 3 inches. They run them outside and then up the air. And this is how they get the radon gas to dissipate. If you are looking at a house and you see plastic tubes coming out the sides of the house, there's usually 2 of them, 1 on each side, and they go almost up to the gutters, and you think those are, they just didn't hook something up to the gutter. Nope, that's not right. Those are radon remediation tubes. If after you purchase your house, you want to test for radon some years down the road, you think about that, you can do that. You would also, if you had a Geiger counter, which is a device that reads radon particles, if you ran a Geiger counter across a granite countertop, it would register that there is radon in there. But it is not dangerous because granite tops in the kitchen and the bathroom, there's enough air in there that it would dissipate, so it's not an issue. Also, if you're in an apartment or a condominium above the 3rd floor, radon gas does not travel that high, so you are safe there. The last disclosure is one that was being used quite a bit and the use has basically been dropped now. Pedro, are you using full disclosure anymore? Well, we can ask him that when he comes back. But the mode disclosure became popular when we went through the foreclosure crisis, that a lot of properties had been closed up and we had mold problems. So the realtor associations were using it. They have now not used it, but you may occasionally have somebody that's concerned about that. If people have allergies or they're susceptible to mold allergies, they may want to request this. So this would be mold disclosure. Those are the disclosures. If you note, if we can go back to our page.
Which one?
Next page, it should be.
Next page?
Page 12.
Got it. Okay.
You will see in section 8 that there are disclosures. This is I have received or not received. You should also receive, or you can go from your agent, or you can go online and get a booklet regarding it's an EPA pamphlet protecting your family from lead. And then there's also an Illinois booklet on radon testing guidelines and explains that. Those are two booklets that you should receive. You can get them yourself ahead of time just to familiarize yourself with them. If not, your agent can help you get those. Let's go, if you could just roll up a little bit, please. One of the things you're going to get are before we go there, let's go back. One of the things you're going to get is a proration for real estate taxes. In Illinois, we pay real estate taxes in arrears, which means that we pay this year's 2020 taxes will be paid in 2021. 2019's taxes are being paid in 2020. Because of the COVID situation, the counties are now giving some extensions of time to pay the second installment of the taxes, and we'll talk about that. So your taxes, let's look at how this works. If we could go to the next page, 13, please. As the taxes are paid in arrears, you're going to get credit, too far. You're going to get credit. There you go, thank you. If you could go up on that page, please. Good. Yep, too far.
Tricks on me.
Problem.
Ooh, busting the sweat. There you go.
Examples. In Cook County, the taxes are paid, like everywhere, twice a year. The first installment of Cook County taxes are usually due March 1st or right around March 1st. And that installment is 55% of the prior year's taxes. So our example here, as you can see, we're saying the 2019 taxes are $5,000. We agree to have a based upon 105%. So you're going to get more because we're not sure what the total tax bill would be, so we're taking an increase. In the 2019 taxes of $5,000, the first installment is due March 1st, and that 55% of the taxes was $2,750. That was paid March 1st. So you as the buyer are going to get a credit. They take the total taxes, the proration of the 105, minus the payment made. You will get a credit for last year's taxes that the seller owes that you will be paying with the second installment of $2,500. And we do this because we don't want you to have to go and chase, you as the buyer, have to chase the seller to get the tax money. If they move out of state or you can't find them or something, and they say, well, let us know what the tax bill is and we'll pay it, we don't want that risk. So this is why we do this proration. So in our example, since we're closing May 15th of 2020, and it's a leap year, you divide the taxes, the prorated amount, the $5,250, by 366 days due to an extra day this year being the leap year, and you get a per diem of $14.34.43 per day. The liability for those taxes for during the 2020 seller is from January 1 through May 15th, which is 136 days this year. In a normal year, it's 135, but again, this is leap year. You multiply the 136 times the 143443, and that gives you $1,950.82. So at closing, you're going to get the balance of the 2019, the 2,500, plus this 1950.82 for $4,450.82. That's a cash credit you would get at closing. You would then owe from that amount the second installment sometime we anticipate in August of 2020, but we're not sure how much that amount will be. As a protection, your lender's going to take some of that $4,450.82 and put it in your escrow account for real estate taxes. So they will have enough money when that second installment is due, and then they will pay that for you. And that's how it's handled in Cook County. In other counties, if you could just roll up a little bit, please, Evie.
Mm-hmm. Oh, boy.
In the other counties outside of Cook, DuPage, Will, Lake, Kendall, they do the taxes a little bit differently. About May 1st each year, their tax bill comes out. And again, you're paying in arrears. So on May 1st of 2020, the tax bill for 2019 came out. So let's say in this example, we know the taxes for that year, for 2019, are $5,200. In these counties, you will split that tax bill in half. First installment will be due June 1, and it's $2,600. And again, if you are buying, there's some discussion in some of the counties that they may delay that payment even because of the COVID-19 situation. Your second installment is the balance, is again $2,600, and that would be due September 1. So that you would get because you already know that. So there's no factor to figure in. However, you're going to prorate the 2020 taxes. So you're going to take your 19 taxes, 5,200, times that 105% proration, which comes out to $5,460. You then divide that amount by 366, which gives you $14.9180. Again, from January 1 through May 15th, it's the seller's obligation. It's 136 days. You multiply 136 times the prorated, the per diem, and that's $2,028.85. So in this closing, you're going to get the $2,600, which is the balance of the 2019 taxes, plus the prorated amount for 2020 of $2,028.85. That, again, credit will come to you at closing. And again, your seller is going to take parts of that, usually 3 to 4 months, and put that in your escrow account so you'll have money to pay the tax bill when it comes due September 1. If at any point you have any questions on anything we're covering, you can drop a note in the chat box and we'll get to those questions as we proceed. The attorney review period. Typically, it's 5 days, but often we need more time, and it's a courtesy that time is extended. If they don't want to extend it, they're killing their deal. So it's custom and practice to extend it. Which point, if for some reason something comes up that you're not comfortable, or there's another issue arises, the attorney has the ability to terminate the contract for any or no reason, and it doesn't have to state why they're doing it. There is also then in this section, if we roll down section 12, the inspections. You have, again,
I'm sorry.
that's fine.
Right here?
You're just rolling down. There you go. Yeah.
Okay.
You're good. Section 12 is professional inspections and notice. And in that section, you have the right to go and get your inspection done. You have to use a licensed Illinois home inspector in order to have your attorney go back to the other side with any inspection issues. You cannot use a brother, a sister, mom and dad, friend, boyfriend, woman or man you want to impress, or anybody else, cousin, as an inspector unless they are licensed to be a home inspector. They are welcome to come with you, or at another point do walk through with you if the seller will let them do that. Prior to our starting, Pedro and I were talking today, because the COVID-19, on an inspection you cannot have more than 4 people. The inspector, the agent, if he or she is going with you, and you and someone else, spouse, partner, whatever. And typically they're wearing masks. They're required to wear masks, gloves, and in some cases, booties, right, on the shoes. So don't be offended if you're asked to do that. The inspection, again, is looking for defects, not necessarily things you don't like. You don't like the color of the room painted blue. You want the seller to paint it gray. That's not going to happen. That's not a defect. That affects either habitability, the ability to live there, or safety issues. Once we get the inspection, usually takes, and coming up next is Jesse Mills, and he'll go through all that, 2 to 3, maybe 4 hours, depending upon the house. In which case, then within the next day, typically, the inspector will send you via email his or her inspection report. The attorney likes to see that because we want to go through that and discuss with you what items need to be corrected. We then, in the attorney review letter, put in there, these are the issues with the inspection we'd like you to take care of. The seller can then say, no, I'm not going to correct anything. The seller can say, I'll fix some things. The seller may say, I'll tell you what, I'll give you a cash credit at closing because I don't want to do the work, you do the work, and I don't want the headache, you take the responsibility. People ask, what's the best thing to do? That really depends upon what the item is, what work needs to be done. The issue with this is always, is the cash credit sufficient to cover the work? You think it's going to take, somebody tells you it's going to be, and I just want to say, inspectors do not give opinions as to what a cost is. They are not experts in that field. So you have to independently go and try to get some estimates or invoicing on what the work would do. So let's say it's the electrical panel needs to be replaced, and you get some estimates, and somebody says, okay, it's a $2,000 job. And someone tells you, well, they could do it for $1,000. Well, I'm not sure that's your best bet. But the seller's going to come back and say, hey, you know, I know somebody that would do it for $500, so I'll give you, let's say, $750. That would not be enough to cover that repair for you. So you can either accept that, or we have to negotiate more money. again, my opinion on that is it all depends what the repair is or what the replacement is, and is it something that if you're not happy with, what are we going to do? So you can think about that, but be prepared if there are a lot of inspection issues. Sometimes you may need another inspector to come out and look at something. Your home inspector may say that the roof looks worn and there's issues with it, that you need to get an inspection, or you need a roofing contractor to come and look at the property. In which case, then you want to go out and have that inspection, and our inspection period will continue while that's being reviewed. You may need a plumber to come out and look at an issue, or electrician to have some idea of what the repair or the replacement, what needs to be done. There are a number of villages, but not the city of Chicago, that require certain inspections before one can sell a home. If you are purchasing in a village that's not, or a city that's not the city of Chicago, you may want to be familiar with does that village or city have an inspection requirement? And if it does, then the seller goes and they get the inspection done. They get an inspection report of what needs to be repaired before the city will allow the property to be transferred. In almost all cases, the city will allow the buyer to assume that responsibility in order to close, because otherwise it may take longer to get the repairs done, in which case then we are negotiating with the sellers for a cash credit to have that work done. Continuing.
Next page.
We're going to go next to next page, please. Oh, you're right there. Okay, great. Yeah.
Okay.
Section 14 is flood insurance. If the property is located in a FEMA designated flood area, you may be required to obtain flood insurance. Flood insurance is different than a homeowner's policy that has sewer backup. Flood insurance covers the flooding due to storms, hurricanes, tornadoes, things like that. It's FEMA, which is a government Federal Emergency Management Association. They designate certain areas to be within their boundaries for water coverage. So you have to then get a flood policy. A flood policy, insurance policy, is an additional policy. It runs about 1.5 to 2 times the cost of a homeowner's policy. And you would continue that policy each year as long as you have the mortgage. The mortgage documents state that if at any time during your mortgage, let's say you have a 30-year mortgage, FEMA determines this to be a floodplain or a flood area, you at that point have to obtain the flood insurance. So if you are buying close to water and you like the view and you want to fish and be on the rivers and things like that, just be aware that you're probably going to be required, if you have a mortgage, to have flood insurance. I always put in my attorney review letter that the property is not or is deemed FEMA, and that they have an insurance policy that we get to see what it looks like, so we have some ideas by cost. If it is in a floodplain, flood area, you have the right to, this is a contingency, to cancel the contract if you do not want to purchase the insurance. Where are we going? Okay. Let's also here, the next section is 15, and that is the condominium or common interest associations. A condominium is a unique property that you are tied to other owners in a common area, common interest, if you will. You get your unit and you have an interest in the common area. There are documents that need to be provided. If you could move to the next page, please.
Sure.
And there are certain disclosures that are required under Illinois law.
Whoops.
That's okay. Just move on. 17. This is the,
17.
you're too far. Go back one more. Oh,
I'm on 16.
there you go. That's good. If you could just scroll down a little. There we go. This is what we call the 22.1 disclosure. Each of the associations are supposed to must provide this to you. And this is information about the condominium association. What their reserves are. Are they subject to litigation? What, again, a confirmation of what is the monthly assessment. Is there any special assessments that are coming? Who insures the property? Who is the management company? And this is, our form's about 3 pages. If you could just scroll through it, that's fine.
And you know, Steve, this is very important that I'm glad you're bringing this up, because I notice a lot of people are purchasing condos. So this is really good to go over, because unfortunately with the houses being so expensive, a lot of people are purchasing condominiums. So thank you for doing this. What was your next page, 17?
Oh, you can just scroll through this. But also then with purchasing a condominium, you are going to get declaration, bylaws, rules, and regulations. So I'm representing a party right now. We were concerned, they were buying a condo and they were concerned whether or not there were any prohibitions against their owning a dog that was over 50 pounds. And they were also concerned whether or not there was any restrictions on their ability at some point to use this unit as a rental unit. So those are some concerns that not every association and condominium association would permit. Also, not all condominiums are certified by HUD, in which case you would not be eligible for a FHA-backed mortgage. So you need to know that also. Again, I would caution you that the smaller associations often are self-managed, which means that they're probably a little bit cheaper in their monthly assessments and stuff, but they may not be as up to date or as diligent in all the things they're supposed to do as an association. So under the condo section here, we have the right to see the documents and we have a right to review them. And if we're not comfortable with the documents and restrictions, covenants, and the like, that is a contingency that would be able to be invoked to terminate the contract. Also, depending upon where you're buying your home, your single-family townhome may be subject to a homeowners association. And that may be that they cut the grass and they maintain the streets and the lawns or things like that. In which case, there'll be declarations, there'll be rules, there'll be regulations. So it's not just condominiums in the sense that you think of condos as apartment buildings type structures, but single family homes or townhomes that are in a planned development.
And Steve, that's mostly in the suburbs, right? Those planned, those associations with the single family or townhouses?
Yes, but I can think of many areas in the city where that is. Lincoln Park, far east Lincoln Park has some areas where they've developed like that and they're subject to association. Up on the Chicago, Skokie, Lincoln, Wood, section, there's a number that I know there's some up there that are condos and some that are homeowner associations, but by and large, it's more likely to be found out in the suburbs. Yes.
Thank you.
Oh, you're welcome. If you can roll this up, if you will. Oh, let's go. 17. In the city of Chicago, you as a buyer and the seller will pay a transfer tax to the city of Chicago. This is another cost. It's $7.50 per thousand of purchase price. For the seller, $3. I'm sorry, for the buyer, $3 for the seller. Many other cities in the area have a transfer tax. Some, the tax is strictly the seller's responsibility. Others, it's the buyer's responsibility. So that's another closing cost that you have to be aware of. And along with that, in the city of Chicago, if it is a single family or up to a 4-unit building, the seller must provide you with a zoning certification. They get that from the city of Chicago. They pay a fee for that. They also have to give you a water certificate, which says that the water has been paid. So you get those in the city. Every city in the area that I'm aware of, the water bill has to be paid typically before or at closing. And that is a seller's responsibility. But some of the cities require 3 days ahead of time to come out and look at that. Most of them, depending upon, again, the size of the city, you can get it, the seller can get it done in a day or two. But without that, they can't record the deed. So that's an important part of the seller's obligations to provide that info for you, and you would see that at closing. You also are going to get, the seller is required under this contract, under Section 18, to provide you with a title commitment. A title commitment is a review of the property's history, and it tells you such things like who's entitled. Being entitled, again, who is the owner? Are there any liens on it? Is there a mortgage lien? And remember, in Illinois, the mortgage is a lien. You are the owner. The mortgage is a lien. In other states like California, the mortgage holder owns the property and you have what we call a legal or beneficial interest. In Illinois, you own it and the lender has a lien. Are there any judgments against the parties, either the buyer or the seller? Are there other liens? Did they not pay a water bill? Does the city of Chicago have any zoning actions against or something? These are some of the things that you would find in a title commitment. The title commitment is furnished by a title company. Usually the attorney is the one who takes care of, the seller's attorney would take care of that, as they are typically an agent of the title company. That goes to your attorney. He or she then looks at it, makes sure, and if there are issues to be negotiated, they will try to do that to get what we call a marketable title, which means they can give you good title at closing. You are then required to provide a title policy for the lender and for yourself, and that is a requirement of the lender. If it's a cash transaction, you as the buyer would still get a title commitment, but you would not have to purchase the title policy. You would want to purchase it to protect your interest in the property. I want to talk about title. If you have done any, if you will, kind of pre-purchasing due diligence, and you've gone to a lender and they've looked at credit, there may be two of you that want to purchase the property, but you may only use one person's credit. The other person's credit is not as good. As such, you want to put, I'd say husband and wife, or domestic partners want to put the other party on title, so upon death, the property would pass to them. You can request from your lender whether or not they will permit that. Some lenders will, others will not. That's not the same thing as signing the mortgage. Only one of you, the person that they're using the credit for, be obligated to sign the mortgage. But you may want the spouse, domestic partner, on the title. If the lender says no, typically what happens is the party that's signing the mortgage goes on title, and then later we do what we call a quick claim deed, where the title holder then quick claims his or her interest to he and she, or to they, if that makes sense to you. And then they are both in title. And that can be done about 30 days after closing, because then the deed has been recorded, the mortgage is gone. There is a little risk with that we could explain later. Don't have to worry about it at this point, but that is some consideration. If you are thinking of adding a person and the two of you are not legally tied, but you're in love, you may want to think hard and fast whether you want to put that other person on title. In the event it doesn't work out, you have an issue. So the 2 o'clock love in the bar may not be the best guiding force on who's on title. But if you have issues, talk to your attorney about how that should be handled. Let's move on. You're also going to get a plat of survey. And a survey is a document that is done by a surveying company that shows you the bounds of your property. Also disclose whether there are any fences encumberancing your property that are hanging over the line, whether there's gutters over your line, whether the neighbor's garage is not properly built and they've encroached your property, and those can be title issues. Also, it helps to have that you would know if you have a fence or you want to replace a fence, where your property line is, and you can do things like that. That will also show you whether there are any restrictions, that you can't build further than 2 feet further on your property because there's a restriction line. There may be side lot restrictions. There may be a rear restriction. It will also show you where the utilities have an easement on your property. And that you typically would see at closing. We usually get that a few days before closing. The title company is also interested in seeing the survey for its title policy. Next page, please.
Ready.
Go ahead.
We're on page 21.
Good. If you could just roll it up a bit, please.
Sure.
Section 22 in the contract is the seller's representations. And these are things that they say that are, you know, this is true, this is true, this is true, what we have done or not done and stuff like that. They also, as you would note there, whether or not there are any assessments, improvements, or anything that are not properly exempted. In exemptions, as a homeowner, as an owner, you are entitled to a homeowner's exemption on your real estate taxes. And that exemption lowers your taxes. You apply for the exemption every year. It's effective. Someone has to be living in the property on January 1st. And the exemption is applied to the taxes on the second installment. So you want to look at that when we do the proration. I look at that and see. There are also senior exemptions. And the senior exemption is for a person or persons that own the property that are living there and are over 65 years of age. There is also a senior exemption, senior freeze, I'm sorry, a senior exemption, the senior freeze. And that is for a party that makes less than a certain amount of money. This year, I believe it was $65,000. And you certify that each year. Also, you have to fill out a form and send it in each year. So if you are looking at a property and the taxes seem lower than other property in the neighborhood, again, look at the PIN, go to the treasurer's, Cook County Treasurer or the county treasurer site, and put the PIN number in and see what the taxes are and see what exemptions they have. So if you're 30 years old and you're buying a property and the party that's selling it are senior citizens, they have a lower tax rate if they have those exemptions, but those exemptions would not go to you. You cannot claim them. So you need to be aware of that again when you're looking at taxes. You can find out what the current taxes are if they're behind and stuff like that. But that's something that the title report and your attorneys would be working on.
Excuse me, Steve?
Go ahead.
Before we continue, one of the clients asked if you can further define liens.
Further define what?
Liens, the liens.
Lien.
Yeah.
What is a lien? A lien is an encumbrance on title. That's the legal description, which means that someone has an interest in the title. A mortgage lien means that if you default on the mortgage, that they have a right to take the property, and they would take it through a foreclosure action. As part of your mortgage requirement, the loan, you would also sign the promissory note. The promissory note is your personal obligation to pay the loan. So if you don't pay, if you default on the mortgage, but you have other assets, they might go, because of the promissory note, the lender might go after those other assets versus the property. Typically, the lender wants the property, they foreclose, they get it back, and they resell it. You might also have a lien, which means that the property cannot be sold or should not be sold because there's a water lien. So that lien has to be paid to the city before you would get clean title. There may be a judgment lien that somebody sued you and got a judgment against you, and they haven't paid that, but they filed the lien against your property. So when that property goes to sell, in order to clean that lien, that person gets paid off. I hope that helped.
Yes, it did. Thank you.
You're welcome.
Quick question, Steve?
Yes, please.
I get this question asked when there's two parties. The gentleman, let's say, is a senior, and the other party on the mortgage is not a senior. Can they still take the homeowner's senior exemptions and senior freeze, even though the other party is not?
Are they living in the property? Yes.
Yes, they're both.
So they do not have to be entitled, and they do not have to be on the mortgage, but they have to be living there.
Thank you, sir.
You're welcome, sir. Good question. I'm glad you're protecting us old people. Okay, what do I want to cover next? Go to page, I want to go section 32. So if you could, which would be, I think 3 more pages.
Gracias, baby. Okay. Home warranty?
Yes, please.
Got it. That's page 25.
Thank you. One of the things that you might want to consider and talk to your agent about is if the house is an older house and the appliances and the mechanicals, air conditioning, heating units and stuff are somewhat older, you may want to request that the seller purchase a home warranty program for you. Typically, they run about $500 to $750 depending upon the warranty, and this would cover problems depending upon the warranty. May include things like roof leaks, electrical issues, the refrigerator going out. And with a home warranty, you pay a fee when they come. It's typically like $75, and then they repair it or they replace it. And that policy is good for a year. You can thereafter get it, renew it for whatever the cost is. Even if the seller doesn't buy that, you may want to consider purchasing that yourself, just to kind of protect you in a situation where the appliances or the mechanicals are kind of worn. The end of the useful life of an appliance or a roof or electrical are not grounds for habitability or safety issues, and typically are not requested, even though your inspection might mention that. That is not a ground that we could bring up with the seller to repair or replace. If you are purchasing somewhere, there might be some very few occasions in the city, but typically outside the city, where they do not have plumbing. Their plumbing is not attached to a sewer system with a village or a city, or they do not have water from a village or city, but they have a well and septic system. Section 32 requires them to provide you with a inspection and up to $3,000 of repairs if need be. If you are on a septic system, on a well system, it's a little different. It's different than having the city and village sewer and water. There is also then section 34, the wood destroying infestation. That's kind of the termite review. If you're purchasing a home that is not all brick and has a lot of wood, you may want to require that. If the house has been boarded up for a while, that you may want to consider that also, request that they provide that. That's not a big expense. Okay, section 35, next page. I want to go as is.
Okay. As is. We're getting a lot of those.
Section 36, as is. I've been practicing law for many, okay, a lot of time. When I was early on in my career, when I would see a contract that had as is, it was typically because of the persons that owned the house. Let's say it was mom and dad passed away, and the children who had not lived there in many years were selling the home for the estate. And as such, they would put as is because they really didn't know anything about the house and they didn't want to fix it up. They just wanted to get rid of it. After the mortgage foreclosure problems, there were many as is, especially if it was a lender that owned the property. They would put as is because they didn't know and they didn't want to spend any money. We sometimes will see people that think their house is perfect and they don't want to do anything and they'll put as is, which means that you, in theory, have to accept the problems and the deficiencies as they are. If the contract is an as is, you should not stop getting an inspection. You still want the property inspected because you may find out that the costs to repair things are way more expensive than you thought, and you may not want to go forward with the contract. Even with an as is, if you get the inspection and there are certain issues, habitability again, that you can live there, and safety, you could still go back, and we would still go back to the seller and recommend that they make these corrections. Because the issue is if they say no and you walk away, the odds are the next party is going to come in and see the same deficiencies. Mm-hmm. So if they want to save time and save money in the long run, they probably will agree to some things. So I would not look at a as is as necessary, a no, but a caution. And again, never stop the inspection because you never know what may turn up. And often, again, as any agent would tell you, every seller, I shouldn't say, 99 and 44 100% of all sellers think their house is excellent and has no problems. And they are often amazed at what comes back with inspections. Okay, last page.
Mr. Cleary.
Sir, I'm sorry. Go ahead, please, Pedro.
So as is, if there's an issue with a safety or hazardous problem in the property, does that constitute the as is, the seller not getting away from fixing that, or if due to the fact that it's a safety or hazardous, they must, even though they're selling the property as is, they still have to repair that?
No, there is no requirement that they repair anything, even if it's a safety or habitability issue. The safety and habitability issue comes up in what you can ask for under the inspection. So again, if it's a cosmetic thing or an aesthetic thing, I cannot raise it. I don't like the way the blinds look in this room. Okay, that's an aesthetic thing. That's not a safety or habitability. So that cannot be raised as part of the inspection. And then as is, you know, anything's fair and stuff like that, doesn't mean they have to do it. Even with, Pedro, as you know, even without the as is, they can say no to any request for the inspection. Again, what happens though? You walk away, what's the next party going to do? And the next, you know, this was the same problem that the banks eventually got smart on. If you remember back when the banks owned all the property, they would say no, and the people go, okay, so it's not worth it. Then they'd have another contract. They would walk away. Eventually, somebody in a bank got smart and said, you know, we're losing time, we're losing money, and each time the price isn't any better, it's less, and we lost it. Maybe we should fix some of these things, especially safety issues or habitability issues. Okay, good question as always. On page 13, you're going to see this is the information page. On the line at the top, 616 across, is the date of acceptance. This is the date that the contract is accepted by the sellers, and this is a date that we referred to at the beginning of this presentation as the clock ticker. This starts the clock ticking. There's also other information that you try to fill out on this page. And that is pretty much the contract review. I'd like to quickly kind of go through the closing. Nowadays, we close at a title company or an attorney's office. Years ago, many years ago, again, we used to close at the banks. The banks don't close anymore. So at a title company, the parties get together and they close the transaction. The title company does not represent anybody. They are a facilitator. They do not represent the seller. They do not represent the buyer. They do not represent the lender. They facilitate the transaction. They get paid for that. They collect the money. They collect the documents. They file the recordings. They send the documents back. Typically, you're going to get that closing CD, which gives you 3 days to reject. And if you reject, then we have no closing. We schedule closings depending upon the availability of the parties. Prior to the closing, you're going to do either the night before, the day before, or that morning if you're closing in the afternoon. You're going to do a final walkthrough inspection to make sure everything is correct, that all the items that are supposed to be there will be there and are there, and that there is no damage due to the party moving out. If anything is missing or there is any damage, we typically at closing then try to negotiate a cash credit to take care of that. We really prefer that there be no problems, but there sometimes are. If the parties aren't out and they need a little more time, like you're closing at 10 o'clock, but their movers won't be done till 5, excuse me, we will hold back some money to make sure there is no damage and that everything gets done correctly. For closing, you will need to bring money, most likely. If it's more than $50,000 you are bringing, you have to wire transfer those funds. If it's less than that, you can bring a certified or a bank cashier's check. You cannot bring a personal check. You should bring your personal checkbook in case there are any last-minute odd amounts, a few dollars. They'll take a check up to probably about $1,000. At the closing, your agent may or may not attend. Your attorney is going to attend. You should attend. In the past, you could bring family and friends. The closer attends. Nowadays, because of the COVID-19, closings are completely different. People are wearing masks. People are wearing gloves. People are wiping everything down, and they want as few parties as possible. Typically, they want the borrower or borrowers and their attorney, and that's about it. Often the seller's not coming anymore. He or she may, the seller's attorney may or may not come. They are closing somewhat if you want. If you're concerned about things, you can sit in your car and sign documents, and the title officer stands outside. We are pre-signing documents now depending upon the lender. I had my closing last, what did I do, Wednesday of this week. I went to my client's house, got everything signed. I was the seller. I went to the title company that morning, gave them everything. The buyer's side sent everything by email. So I was the only one at the closing other than the title agent. That is kind of the way it's going to continue for a while. So it's tough on families. I don't have good answers for where to put the kids. If it's an issue, I guess you could do it from your car, but talk to your attorney as you get close to that and how that would be handled. And a lot of that depends upon how the lender wants to see signatures. The big issue is the notary, and the title companies in the state have worked through that. The other thing you need to bring is an ID, your ID, driver's license, passport, state ID, a current one that has a picture. I always recommend you bring a backup one, a second one, a credit card, student ID, or something like that also. Anticipate, I always say 2 to 3 hours. Most of them have been running under 2. I would just caution you nowadays that it may be less, but it may be more depending upon how it's being conducted, what parties are there. Once you are done, you get your keys, you're moving to your house, you're anxious to have everybody come in and see the new house, and strongly recommend the first person you meet at the door is a locksmith, and that you change the locks. No matter how many keys you got, nobody knows for certain that those are all the keys. Even if this is a brand new house or they put brand new locks on, they can have masters and stuff like that. Get the locksmith there, change the locks, control the keys. That first night, knowing you're the only ones with keys, would be the best sleep you'll probably ever get in your house. Are there any questions, Caesar?
No questions.
Okay, in that case, I thank you all. I wish you the
Mr. Cleary, Mr. Cleary.
Yes, sir.
I got one for you. As a legal expert, I get this question asked a lot as I'm out showing properties with my clients, and they see a couple of homes that they're interested, and they tell me, Pedro, can we put 2 or 3 offers on different properties? As a legal expert, what do you recommend for that?
You could do that, but what's the risk? If they're all accepted, what are you going to do? I would say, my friend Pedro, that makes you look bad, not the client. But
I
you
get
can
that
do
from
it.
the client. I try to tell the clients that, if they do that, they're basically purchasing 2 properties. From the legal standpoint, you know, they can always get out of one property or the other, but they don't understand what the consequences are of going through all that. And I get that asked all the time. Well, Pedro, if we see two good properties, why can't we put offers on both properties if we don't want to lose neither one of them?
There is nothing prohibiting them from doing that. Again, it's just my perception. I would say the perception is that you stand more at risk. You know, as a guy who really doesn't bring good offers, he just throws a lot of stuff out there, or she throws a lot of stuff out there. I think that happens. If the shoe was on the other foot and that happened to you, would you be happy with that?
And they don't understand the consequences. They just believe that by putting in an offer is an offer. And I try to tell them, you know, we have to pay close attention to what the market is doing. We have to be realistic on the offering because we don't want to disrespect the seller. We want to make sure that we have a continued relationship with the listing agent and the seller who they're representing so that we could get to a common point, which is ultimately get them the property that they want.
Yes, yeah, good question. But legally you can do it. You know, business-wise, I don't think, you know, there might be a unique situation. I guess if I was going to do it, I'd put a time limit on one of them.
Steve, I have another question for you.
Yes, please.
If a home is in a flood zone, is there any extra precautions I should take prior to closing? Can I ask for information on past insurance claims?
Yes, you can. I always do in my attorney review letter. Ask if they've filed any insurance claims within the past 3 years.
Adrian, does that answer your question? Yes, thank you. That's it for me.
That's it.
Hello, everyone.
Hi, Jesse.
Hello, Jesse.
Jesse, we're gonna take a 5-minute break before we start with you. Does anybody else have anything else for Steve? Going once? Going twice? TMI, they want a break. All right, guys, we're gonna take a 5-minute break. I'm gonna set up Jesse's PowerPoint and we'll come back at 11:40.
Five.
Sorry. Yeah, 11:40. I'm sorry, 11:45.
Yep.
Jesse, stay on the line.
Yeah.
Okay.
Can you hear me?
I can.
Pedro and I, prior to my discussion today, kind of raised the issue of how are you handling, in his case, how is he handling previews of homes and stuff like that? And he said he's limited to 4 people. What are you doing?
Well, it's a myriad of things. Sometimes I get 4 people, sometimes I get more. It's, you know, every real estate company is going to have their own little, their rules. Like Jamison Sotheby's,